Good morning, everybody. My name is Jalen Carter. I'm the Community Program Manager at the Tulane Innovation Institute, and we're back today for a webinar on IP monetization strategies. We are fortunate enough to have our presentation today from AJ Zucchero. I'm going to read his bio, and then we're going to get started. So, AJ leverages his extensive experience as both a researcher and intellectual property professional to assist clients in maximizing the value of their innovations. As a patent agent, he represents large multinational companies, growth stage companies, and universities in a variety of chemical, pharmaceutical, polymer, and nanotechnology patent prosecution matters. AJ also has several years of experience in assisting the preparation of patentability, freedom to operate, and invalidity opinions. AJ has worked closely with clients to protect valuable intellectual property related to small molecule therapeutics, pesticides, agrochemical formulations, drug delivery, paints and coatings, surfactants, enhanced oil recovery, biodegradable polymers, adhesives, thermal interface materials, catalysts, thermoplastics, electronic materials, tissue sealants, bone cements, anti-fouling coatings, wastewater treatment, pulp and paper chemistry, scanning probe microscopy, fluorescent probes, polymer nonwovens, microfluidics, and medical devices. Prior to transitioning to a career in IP law, AJ amassed nearly a decade of research experience in organic chemistry, polymer chemistry, material science, and biochemistry. He graduated from the University of the South with a BS in chemistry. As an undergraduate researcher, AJ synthesized and characterized a novel family of glutamic acid-based organogels and metallogels. AJ also spent a year examining the mechanisms of stereochemical control in the macrolide ring synthesis of the antibiotic erythromycin A in Saccharopolysporata erythraea. That's a fun word to say. While pursuing his doctoral degree at Georgia Institute of Technology, AJ synthesized and characterized responsive fluorophores, both small molecules and conjugated polymers, for advanced applications in biosensing, environmental detection, and optoelectronic devices. He received a graduate student fellowship from the Center for Organic Photonics and Electronics. AJ also worked as a research chemist with a micro-optics company developing novel security and anti-counterfeiting measures. AJ is an accomplished author and technical speaker. He has co-authored numerous technical publications in journals including Accounts of Chemical Research, Journal of the American Chemical Society, Journal of Organic Chemistry, Organic Letters, Macromolecules in Chemical Communications, and Chemistry, a European journal. He has also presented his research findings at conferences, including multiple national meetings of the American Chemical Society, the 9th International Symposium on the Metallomesogens, and the 8th International Symposium on Function Pi Electronic Systems. AJ is also a co-inventor of an issued US patent related to laser markable devices. AJ, thank you so much for joining us. The floor is yours.
Great, thanks, Jalen. I appreciate the introduction. So today I'm going to speak with the group about IP monetization, and the talk will sort of have two parts. And I'll say at the outset, I'm happy for this to be as interactive as possible. So if you have a question or want to touch on something a little bit deeper, feel free to interject, raise your hand, put something in the chat, and maybe Jalen can spot that for me and flag it. And I'm happy to sort of make this as valuable and useful for you as possible. So today we're going to talk about sort of two topics in a sense, with a goal of getting to this idea of IP monetization. In the first part, since my understanding is a lot of you are involved with startups or early stage companies, or maybe thinking about getting involved in a startup, I want to talk to you a little bit about how to build that IP portfolio that you're going to monetize, right? What are some steps and thoughts you should have as an early stage company or an entrepreneur about how to think about developing an IP portfolio that is worthy of being monetized, right? That's gonna bring you some value. And then in the second part of the talk, I'll mention a few different IP monetization strategies and that you should be aware of and kind of understand. So that if you're in that position, you can sort of know what questions you need to ask somebody. However, I'll give you the caveat up front. There are as many IP monetization strategies as there are folks monetizing IP, right? It's a very customized process based on the industry that you're in, the stage of your company, its relative market share and position with competitors, its IP portfolio, et cetera. So even if you look at, say, large tech companies in the Internet of Things space, for example, you'll see that they employ different IP monetization strategies that are sort of tailored to meet their needs. So there we'll talk a little bit about some different options, and I'll kind of highlight those distinctions for you a little bit, and just encourage you, if you're in that position, to consult with somebody who's got experience and can help guide you through the process of discerning which strategy is going to work best. So with that, we'll dive into the concept of sort of what you need to be thinking about as an entrepreneur to build value in your IP portfolio. At the outset, sort of what is IP, and I'll breeze through this because I think most of you are fairly familiar, but just want to make sure we all have a little bit of background. So intellectual property, or IP, is basically product of the human intellect that the law protects from unauthorized use by third parties. And it's sort of valuable to think about why this has become so important in, say, the last 50 years in the American economy. And if you want to see how important it's become, you can look at metrics, for example, such as the number of patent filings per year, and see that this is something that's exploded over the last, say, 30 years in the US economy, global economy. Why is there so much of a focus on intellectual property these days? Well, if you think about, sort of the evolution of economies from the agricultural age through the industrial revolution and industrialization to now what is often termed like the knowledge economy, um, different inputs control value and growth in organizations, right? So in the agricultural age, it was really all about physical inputs, right? Your labor, your land, and access to natural resources. That was going to determine how much value you could build, right? With industrial revolution, capital became an important input, right? Because we had to construct these factories and machines and plants that would allow us to turn our labor and land into products for market, right? So capital became really important in the Industrial Revolution. In the modern knowledge economy, increasingly, labor and land, those natural resources, and time matter less, right? Capital, it's important, but it's really secondary to knowledge, right? Knowledge is what governs sort of how much value you can build in an organization and a company. And the problem is, unlike labor, land, and capital, knowledge isn't inherently excludable, right? It's sort of infinite. And Therefore, IP has become extremely important because it is the mechanism, the legal framework around intellectual property. It's the mechanism by which you create some exclusivity around knowledge, and that allows you to really build value in today's modern economy. There are kind of four big buckets of IP that you should be aware of as an entrepreneur. There are patents. That's kind of, I think, what most people think of when you say IP. These are most often utility patents that protect useful inventions. There are also design patents that protect the sort of way an article looks. So not its functional characteristics, but its aesthetic appearance. And there are also plant patents to new varieties of plants. Copyrights protect creative expressions of ideas. So not the idea itself, not the underlying thing, but the creative expression, right? The movie, the song, the article that's written with the idea in it. Trademarks and trade dress are related. And they're essentially, you can think of them as a basket of, names, logos, symbols, designs, etc., that indicate the source of a good or service. So not the actual article itself, but who produces it, right? And then trade secrets are confidential information that a business can obtain and keep secret and create an economic advantage by virtue of maintaining this information in secrecy. And there are sort of different advantages to each of these buckets of intellectual property, right? They have differences in terms of what they can protect, differences in terms of how you can use them to exclude third parties, differences in terms of how they're enforced, differences in terms of how long they last, right? And most companies, particularly large companies, as they become more mature, will use a mix of these different types of intellectual property to sort of maximize their advantage. I'll touch real briefly just on trademarks and patents because I think those are the areas that are sort of most common. I mentioned trademarks, they're source identifiers, right? The thing to think about that most folks miss with trademarks is it's much more expansive than sort of the logo you see on the screen on a commercial or the catchy phrase on the sign. It can really be expansive. It can be pretty much anything as long as it indicates who produced the good, right? Everything from Owens Corning has a trademark on the color of the spray foam insulation, that pink insulation, that's trademarked. Or the color of a sole of a pair of dress shoes might indicate its maker. The roar of the lion at the beginning of an MGM movie, that's trademarked. The little swirl on top of a Dairy Queen soft serve ice cream cone, that indicates that's a Dairy Queen ice cream cone and not anyone else's. Recently, Play-Doh trademarked the smell of Play-Doh, right? Which, for those of us who have kids, you can tell the difference between Play-Doh brand Play-Doh and its very distinctive smell and sort of the store brand knockoff, right? So it's very expansive. And the goal is really this, that somebody can hand you something and you can immediately know the source of this beverage, right? There is no doubt that this is a Coca-Cola soft drink. And that's because they have they've not stopped at just one. They have covered every inch of this can with trademarks that make it very clear what the origin of that beverage is, right? Patents are a quid pro quo in essence that is used to protect useful inventions. And the quid pro quo works like this. You come up with some interesting article of manufacture, let's say, that you think is worthy of patenting, and you go to the patent office and you disclose that article of manufacture. You explain what it is, how to make it, and how to use it. You tell the public all of the secrets associated with that article of manufacture. And in exchange for sort of putting all that into the public domain, the government comes back and for a limited period of time, in the US it's 20 years, they give you a monopoly on that article of manufacture. So it's an exchange, right? We give to the public an understanding of our invention, and in return for making the public aware of the secrets, right? Sort of pulling back the curtains and letting everyone know what I've done and why it's important and how it works. I get to use it exclusively for a period of time. And the idea is, from a public policy standpoint, that this is going to foster innovation, right? Because you're putting all the information about the products in the public domain and allowing third parties to see what you're doing and potentially innovate iteratively off your innovations. In order to make that quid pro quo work, there are some statutory requirements for patentability. The first is we want to make sure it's something that's eligible for patenting. In the U.S., this is the 101 requirements. So essentially, the law defines certain things you can patent and certain things you can't. Each country, by the way, has different sort of rules of the road. The U.S. is very permissive. There's a Supreme Court case that says anything under the sun made by man is patentable. So we have about the most permissive subject matter eligibility in the world. And as long as it's not something like an abstract idea or a law of nature or something like that, you can probably obtain patent protection in the US. Other jurisdictions are much more restrictive. Europe doesn't allow you to patent methods of medical treatment on human patients. India doesn't allow you to patent agricultural methods, right? And these are all public policy balancing acts where countries will decide certain areas they don't want to convey monopolies on, right? As part of that quid pro quo, we want whatever you're telling us to be new and innovative, right? And so we have the novelty and non-obviousness requirement. And then to make sure we're getting our money's worth for the monopoly, you got to really tell us what your invention is, how to make it, and you got to tell us the best way you know of using and making your invention, right? And that's the written description, enablement, and best mode requirements. And so there are a lot of different statutory requirements and other issues that come into play. But as an entrepreneur, just think that all of this really relates to that quid pro quo arrangement, right? And making sure that the government's sort of getting a fair shake. It's getting everything into the public domain that it needs. And in exchange, you're getting that monopoly. The process for obtaining a patent is something that I think entrepreneurs need to understand a little bit because it's going to relate to a lot of the strategic decisions and planning decisions that you make, particularly in an early stage business when patent applications may be crucial to fundraising efforts, product launches, etc. So generally speaking, you're going to begin by filing a priority application in the US. This is usually a US provisional application for most companies. It could theoretically be a non-provisional application as well, but you're going to start, in most cases, the process by filing that first application. And then that sort of starts a clock within of 1 year, 12 months. And within that 1 year, 12-month period, you file a full non-provisional application. Oftentimes, this will be what's called a PCT application, which is an application filed under the Paris Convention, or excuse me, the PCT Treaty, that allows you to pursue international patent protection from that document. So you'll file a PCT, for example, at 18 months after initial filing, your application will publish. That'll be the first time the public will be aware that there is a filing in place. And then if you filed a PCT application, as most folks do, at 30 months, you'll pick which individual patent offices you want to pursue protection for. So you can imagine as a US company, you might start with a US provisional application. At 12 months, you file your PCT application. And then at 30 months, you decide, gee, I want to pursue a patent in the US, maybe before the European Patent Office, in China and Japan. And you'll file national phase applications in each of those countries. And then each of those countries, you'll undergo what's called an examination process, where the examiner will look at those statutory requirements for patenting. They'll look at your application and they'll decide whether you're entitled to a patent and what changes may need to be made in order to allow the patent to be granted. If you think about the timeline from the day you show up with your priority application, you have 1 year to make your non-provisional application. At 18 months, your application publishes. At 2.5 years, you need to know what national phase applications you're going to be filing. And then from there, it's going to be another 1 to 5 years, depending on the country, before you might reach a decision about grant or refusal, right? So this is a fairly protracted process. And you'll note that the costs sort of accelerate, right? They're back-ended. So if you're thinking about this from an entrepreneur standpoint, when you file that initial provisional application, oftentimes that doesn't seem like too onerous of an expense, right? But understand that assuming you're going to prosecute all these patents to issuance, there is a significant cost on the back end. And you've got to sort of think about that in terms of your business structure, fundraising, and so forth. A few pitfalls that you should be aware of as an entrepreneur thinking about filing a patent. The first is around that first filing date when you file your priority application. So the novelty and non-obviousness requirements essentially point to the need to file that priority application before you publicly disclose the invention, right? So you can make the mistake of filing too late, going out and disclosing something publicly uh, offering a product for sale, publishing a scientific manuscript, whatever it might be, putting that invention into the public domain before you've got the priority application. And then that event becomes prior art and might compromise your ability to get a patent in the US or maybe in other jurisdictions. You can also make the mistake of filing too early. So when I file the priority application, I have 1 year to file my non-provisional application. Once the non-provisional application is filed, I can't make any more changes to my specification. I can't bring in any new disclosure to that document. So if I haven't sort of fully crystallized the application, the invention, I don't understand how maybe to make or use the invention yet. I don't understand the particular components and structures that I'm going to need. I can file too early, and then I don't have the disclosure in the application that I need to get the claim, the coverage that I need from the patent on the back end, right? So the timing of that priority filing is really important for entrepreneurs to think about. Candidly, with most startups, that date is going to be forced on you, either through some publication, through some need to go seek fundraising. Essentially, the need for publicity, the need to get the idea out there is usually going to be the driving force for most folks. On sort of more mature companies, a lot of times you'll choose to keep things under wrap and develop internally, sort of live in stealth mode until you can sort of strategically launch. And then you can be a little bit more tactical with things. Uh, in that in that 1 year period between your priority filing and your non-provisional filing, you do have an opportunity to add additional data and disclosure. So you definitely want to take advantage of that. And ideally, when you're filing as an early stage company, I try to talk clients through a kind of a timeline, right? We're going to file today. What are we going to do between now and a year from now when we file that non-provisional application as far as generating additional supporting data, working out other embodiments so that we have a roadmap for what we're going to have at 1 year when we file our non-provisional application. We understand where we're going with things. Another interesting strategy that oftentimes clients still think about is requesting search or examination in that intervening 1 year. So there are different strategies by which you can do this. You can have an attorney or a search firm do a patentability search for you, or you can file in a lot of offices that will allow an application to be searched right away. So you can file after you file your US priority application, you turn around and file in the UK, for instance, and you can get an office action from the UK right away, usually within 3 months. And in one way or another, by getting some information about patentability in that 1 year span, you give yourself the opportunity when you write the non-provisional application to know what the prior art is that patent offices are likely going to have in hand and make adjustments to your non-provisional application before you file it, right? So that you've already got the disclosure you need to overcome those references that you think an examiner might cite against you. It's a really important tactic, in my opinion, for a lot of folks, particularly if you don't have a good vision on what the prior art landscape might be. Another pitfall is choosing the wrong non-provisional filing strategy. This can take the form of, selecting US only when you need international protection, or filing a PCT and forgetting about maybe some non-PCT member countries like Argentina or Taiwan that might be important depending on what business you're in. So knowing what non-provisional filing strategy you need can be important. Not filing follow-on applications before publication is a big downfall. So once your application publishes, it becomes more fully available as prior art under most legal regimes. And so if I have some innovation between month 12 and month 18, I may be able to file another application and not have my earlier pending application cited against me as prior art. And that can be a really big advantage. So don't miss out on that opportunity if it comes up. Disclosing too early. So in that 18-month window, things are maintained in confidence, right? And so you don't necessarily want to make disclosures. In particular, you don't want to disclose anything that's not in your application. It's usually safer to wait until publication of the application and then have your disclosure be that application, right? That's what you share with third parties. And then the last one is the incorrect national stage filing strategy, right? Not picking countries that are important On the flip side, for early stage companies, picking too many countries, because there's a lot of cost associated with each of those countries, and you burn a lot of capital. So sort of tailoring that filing strategy based on your business and your needs are really important. Um, the goal for early stage entrepreneurs should be to align your IP strategy with your company's value proposition. And you should sort of ask yourselves whether the decisions you're making related to your IP strategy are maximizing the value of your company. Um, when you're thinking about filing, you want to ask yourself the right questions before you just reflexively go file on something, right? You want to understand whether the invention is patent eligible, right? Am I throwing money down the drain? I'm not going to be able to get a patent on this. Can I define my invention textually? Essentially, can I satisfy that written description and enablement requirement yet? Or do I need more time to work through this process? Do you want the details of your innovation to become publicly available? Or might you want to hold them back as trade secrets? Um, think about whether you can detect infringement of this idea at all anyway, right? It may be a really valuable method, but if that method's always going to be performed in some high bio level secure facility that nobody can ever get access to, how am I going to know that somebody is infringing on my patent, right? And that might compromise my ability to monetize it or enforce it. Uh, can the technology be reverse engineered? This is really important when we're thinking about trade secrets. If the technology is not susceptible to reverse engineering, if you're Coca-Cola and it's the original formula and it's really hard to reverse engineer, it's a great thing to keep as a trade secret. That's why we still don't know what that original formula is. They didn't file a patent on it, right? But if I can sit down in a room with a team of engineers and work out exactly what your invention is in a week, then the trade secret does no good, because if somebody reverse engineers my trade secret without stealing it from me, they just buy the product and reverse engineer it, that's fair game, and the trade secret can't prevent them from using it if they independently arrived at it. And then also, how does your technology relate to your wider IP portfolio, right? This is always a big thing. Most companies have sort of platform filings. They have filings that are directly related to products. So those two are sort of like core to their business. And then they'll have ancillary filings, right, that are maybe defensive in nature or cover areas that they used to be involved in, but they moved away from because things didn't work and they pivoted another direction. So understanding sort of where the technology relates to the wider IP portfolio makes you understand how valuable it is, how much should I invest in it, how much should I spend in it. And you want to focus your time and energy, right? Um, Multiple filing programs require strategic resource allocations. So you want to think about, which are my most important filings and how do they relate to my products, my objectives, and then you want to focus your attention, your capital, your resources accordingly, right? You want to understand the IP timelines. Um, know what your filing strategy is and the associated deadlines. Kind of think about that 4 or 5 year window, right? And understand, what do I need to support ongoing and future filings? When am I going to need that? Both in terms of data and in terms of capital, right? Understand, like, what's your venture strategy, or how are you fundraising? When might you be coming out of stealth mode? When are you going to be out there doing capital raises? And make sure that your IP portfolio is going to support the investment you're looking for, right? You're not going to be able to go out and raise a bunch of capital if you haven't filed any patent applications yet. You need to have sort of the right portfolio and IP strategy to match where you are in that timeline. Understand how your prosecution timelines all will relate to commercial activities, whether they're regulatory pathways that you'll be going through with a new drug, or just a product launch, right? To make sure that if you need a patent issue to support commercial activity, you've got a pathway for getting that patent to issue more quickly. Likewise, if you're dealing with a new pharmaceutical and the regulatory timeline is 10 to 15 years, adopt a strategy that acts accordingly and delays costs as much as possible, keeps things pending while you sort of go through the regulatory process. Uh, Also, think about your exiting, and I mentioned your fundraising strategy, but think about your exit a little bit, right? Are you planning to be acquired? Are you going to be acquired by big pharma? right? That's got a different expectation in terms of what your IP portfolio is going to look like than if you're going to be acquired by somebody in the tech sector, right? For example, pharma companies generally file in 100 plus jurisdictions. They maintain huge global portfolios. Most tech companies only file in a couple of countries, right? So if you know what your exit strategy is, who your likely acquirer is going to be, that can help shape those foreign filing decisions and make sure that your portfolio kind of matches what they expect, right? Puts you in the best position for maximizing your valuation. Are there particular jurisdictions of interest in your industry or for an acquirer, right? We see this often in, certain industries. So as an example, semiconductors, Taiwan is extremely important. Absent semiconductors, is very rare that I ever see clients file in Taiwan. But if you're in that space, you probably do need to file there, right? Because the vast majority of major players have activities there. It's sort of the center for innovation in that space in many respects. And so not having protection there is viewed as a weakness for an acquirer. If you know your likely acquirer is located in Europe, or is located in Israel or Japan, you probably want to acquire intellectual property where that acquirer is located, right? Or potential acquirer is located. And that might lead you to file somewhere that you wouldn't otherwise. A few thoughts about working with outside counsel. Most early stage companies, they don't have a full-time in-house IP counsel, right? So you're generally going to have external counsel. I find what works well with early stage companies is to have regular IP meetings with outside counsel and the relevant stakeholders, where you can sort of converse about the status of IP matters, whether it's drafting applications or prosecution act anonyms, but also you can help bring the IP council up to speed with the things that are happening in the business, right? The R&D progress that's going on, what competitors are doing, potential collaborations, product development, launches, etc. And this will help your IP council issue spot things that are important that can build value in your business, whether it's ideas for follow-on applications or potential new filings, keeping you out of issues with freedom to operate, where you might walk into a competitor's IP portfolio and not know it exists, et cetera. So sort of the more you can embed your IP counsel in the business as a whole, make him understand what your strategic objectives are, the better they'll be able to use the IP to help build value for your business. Just a few other minor odds and ends to think about as an early stage entrepreneur. You want to develop some sort of inventor capture process, like an invention disclosure form, something like this, that allows you to memorialize and capture innovation when it happens. And then, ideally, that's coupled with some sort of process for assessing the value of that innovation and developing a strategy to protect it and ultimately monetize it. So try to get something like that in place fairly early on, so that you can memorialize who invented what when. And that's very important in terms of making sure you know who the inventors are, when you conceived of something, documenting what you've done, and so forth. Inventorship and ownership and inventorship considerations. As part of that IDF process, always try to document who contributed what to an invention. Not just, Sally and Jim worked on this together, but here's what Sally did and here's what Jim did. And that's going to help your IP counsel make sure the inventorship is correct, which is important for the validity of the underlying patent. Make sure you're getting confirmatory assignments from all of your employees when applications are filed, to make sure that, sort of the title of the patent application is buttoned up and you own it. That's always a big thing in due diligence. Make sure you know the nationality and location of inventors. That can have important impacts on where you can file and what might be required in some cases to file in certain offices. So make sure you know that information and you convey it to your patent attorneys. Try to work on educating stakeholders about IP, and your IP counsel can help do this, particularly in those meetings. But you want your folks on the ground, whether it's your R&D team, the folks who are doing product development and business development, you want them to understand IP so that they spot things that they're developing that are potentially innovative, so that they don't unintentionally disseminate information to a third party and so forth. You want to make sure you have employment contracts with IP provisions. This is very important in early stage companies in particular. So, make sure you've got those in place. The same with collaboration agreements. If you're entering into a joint development agreement, some sort of joint development program with a third party, you're going to work collaboratively on something. Make sure you memorialize that agreement, including what happens to intellectual property developed under the agreement, what happens to intellectual property of the two parties that they held exclusively before the agreement started. What happens to that IP once the agreement kicks off, and so forth. As you get more mature, you'll want to have a disclosure protocol. This is particularly important in sort of pharma, life sciences, biotech, where the need for scientific publications is really important. You need to have a process that allows an individual who's going to go speak at a conference or going to go present a manuscript for peer review to understand that they can't just do that. We need to clear that submission, that public disclosure, make sure everything that's in there has been protected before that disclosure occurs. So that's something you need to put in place potentially early if you're in sort of the biotech life sciences sector. And then, as you grow, you need to think about employee transition, right? How do you bring new team members up to speed, and how do you offboard folks, right, as they leave and move on to other things, making sure that you're obtaining the documents you need for patents and getting information that you might need and so forth. I'll mention kind of one other topic that's important, and that's competitive intelligence. And it's important for a variety of reasons. We need to understand what the landscape we're acting in commercially looks like. We want to monitor the activities of known competitors. We want to identify emerging players that we may not know about, so that we can spot and act on opportunities and gaps. We also want to identify and act on potential issues, whether it's potential concerns about our freedom to operate. Does somebody else have a patent that's a problem for us that covers what we want to do? Is that patent valid, right? And then on the flip side, is somebody infringing our patent? Is somebody getting into a space that we care about? How can we exclude them, right? So this is really important. It's also going to be important, kind of walk hand in hand with fundraising, right? Because this is often an area that VCs and others care a whole lot about. Understanding that you understand who your competitors are, what that landscape looks like, where you do and don't have freedom to operate, what your strategies are for addressing freedom to operate concerns. So how do you gain this competitive intelligence? How do you understand what FTO is? Well, you're going to need to have a strategy for looking at sort of informal searches, your existing knowledge, looking at search report from patent offices, maybe even targeted searches in the case of patentability, validity, or FTO concerns. But you need to gather information from all available sources. When you're a small business early on, I try to use sort of existing knowledge, informal searches, and patent office search reports, right? Try to avoid the expense of going out and hiring a searcher and doing a formal analysis. But, when you go to a trade show, write down the names of the 6 companies you see that are in the same space, and then go out and look and see what filings they have that are public, right? When you get a search report on your platform technology and you see 6 patents have been cited in the search report, who are those companies? What do those patents cover? What other patents do those companies have, right? So in an early stage, try to use those, let's call them free or low cost strategies for gaining some competitive intelligence. And then as you move on, you can become sort of more regimented and do targeted searching. Or for larger businesses, a lot of times we have monitoring programs where every month they're pushed a list of all patents in certain areas with certain keywords in the claims that issue, or they're pushed all of the patents that a competitor of theirs issues or publishes, right? So those are sort of more formal monitoring strategies. One big thing that I see in due diligence is an issue all the time. It's really important. Understand that granted IP rights are not freedom to operate. These are different concepts. So just because you have a patent on a product does not mean that you can sell that product. And by that, I mean it does not mean that a third party doesn't also have a patent whose claims cover the product that is in your claims, right? And this often is an issue that can really raise its head in due diligence with VCs, et cetera. I've seen many times when I've done due diligence on behalf of VC firms, so on the other side of the table, an entrepreneur answering questions about freedom to operate by saying, well, we have a patent on that. Well, that doesn't mean that you have freedom to operate, right? So understanding that concept is extremely important to make sure you're addressing this concern. With respect to FTO, the first thing I'm going to say, don't run out and do a full-blown opinion and spend $50,000 on that, right? It's a very expensive process, and it's not appropriate for an early stage business to do at the outset. What you want FTO to be is an ongoing process that's ideally staged as a business matures, right? And usually it's going to be investors in an early stage company that are asking you these questions about FTO. When I represent investors, what we like to see is that the company has an appropriate answer for the size business they are. So if they're a startup, the answer might be, well, we know of 3 competitors. We know of 7 documents that were cited in search reports related to our product. We've looked at the portfolios of those companies, and we don't see any FTO issues with any patents owned by those entities. That's a very measured response for a small business, makes us very happy, right? We don't need to see that you went and searched every patent, under the sun, and you've investigated Lithuanian patents, and there's nothing that's going to pose an issue there. You've turned over every stone. We don't need to see that. What we need to see is that you sort of done an appropriate analysis in terms of investment and risk at the stage you are, right? And you've appropriately de-risked the investment for us. And so consider it as a staged process, right? You start small, and as you mature, as you get closer to commercialization, you do a little bit more and a little bit more and a little bit more. And you ideally want to start this process as soon as you can, right? Before key features of your product are fixed. As soon as you start fixing them, but before the product is finalized, so that if you find a patent that's a problem, you can pivot and adjust and redesign before you've invested in sort of, production of 800,000 units that you've got sitting in a warehouse, and now I find out, oh gee, I have an FTO problem, I can't sell them, right? That's a bigger problem. You want to sort of stage the process out, start as early as you can, and do a little bit all the time. Ultimately, at the end, before you launch, usually you're going to want to have a real analysis done where you do a search by a third party. Your internal stakeholders and your IP attorney analyze it, and then they memorialize their findings. But as I said, that's sort of the final end. Think of it as a staged process all the way through. When conversing with VCs and others in fundraising discussions, some thoughts about IP strategy. The most important thing is to convey that you have an IP strategy and that it's appropriate for your business. That you understand what IP means, what these terms mean when folks talk about freedom to operate or patentability, or the difference between a pending application and an issued patent, right? That you understand some of these concepts and you understand how they intersect with important aspects of your business. You want to demonstrate you've thought about key value drivers, that you thought about the patentability of your most important pending filings. A big one, that you understand how your pending filings or your issued patents relate to your product or your product development strategy. That's one of the first questions I ask when I'm doing due diligence. What's your product? And then tell me what claims of what patents cover your product. And I can't tell you how often, at least 50% of the time that I'm doing due diligence with an early stage company, at least 50% of the time, the claims that they identify as covering that product don't cover that product. Because the claim was written back on day 1 when they filed their priority application. And then 4 years later, the product development team changed something, and the claim is still covering what they thought the product was 4 years ago, but now the product's moved to this other space, right? And the claims no longer cover it. So understanding the relationship there, extremely important. Understanding your immediate and future filing strategy, how you're going to sort of leverage filings to create commercial advantage is important. That you understand that competitive landscape, what others are doing, why you're different, what are the risks in terms of FTO, and then inventorship and ownership. This is the other pitfall that I see in due diligence. Folks who don't have assignments from inventors, right? If the company doesn't own the IP asset, it's still in the name of the inventors, that's a big problem. So making sure you sort of buttoned up the inventorship and ownership piece is important. Understand there's a big variation in what investors will want to see, and that the responses you give for these questions are going to be commensurate in scope with the size of the investment, the stage of your business, and so forth. For more significant transactions, definitely don't be afraid to embed your IB counsel in these conversations. It's very normal for larger stage transactions for us to speak directly with IP counsel about IP issues. And this protects you as the entrepreneur from maybe misstating or misrepresenting something, right? So you definitely want to demonstrate your fluidity with the concepts, that you understand the high level strategy and so forth. But when it gets down into the nitty gritty details, feel free to refer them to your IP counsel. So now I want to move on in sort of the last few minutes to IP monetization. Why is this so important? Well, we've talked about this R&D process. You're generating all this IP, right? It's a tremendous expense in a business, and it consumes a whole bunch of working capital, and it generates this thing called IP. But IP is, frankly, kind of an intangible asset, right? It's not valued on the balance sheet of your business, and it's sort of like a sunk cost. And the valuation of your IP is kind of hypothetical, right? Outside of say a venture investment or a round of fundraising in a industry that's sort of IP centric. Before some sort of monetization strategy, it's really unclear what this portion of your business is worth. And monetization provides an opportunity for companies to unlock new unrestricted capital, to recoup some of those R&D costs. Most of the time, this can be done in a way that's non-dilutive to the business, right? And it can increase shareholder value. It can fund growth opportunities. It can monetize underperforming assets. And we see this often with businesses. They'll maybe start in one area, and over time they'll pivot. And so they'll have this IP portfolio, maybe a bunch of patents that issued to something they're no longer working on, right? That's not of interest to them. It's a non-core asset, and it doesn't do anything for their strategic advantage, to their strategic direction anymore in terms of supporting product development, the direction they're heading. Right now, essentially that's just a sunk cost and it's sitting there, right? Monetization is a way you can try to unlock some value from that asset, bring some new capital into the business, and fund that new direction that you're going down. There are kind of traditional routes to IP monetization, broadly speaking, and then there are kind of some more modern alternatives that have developed. So traditionally, kind of the oldest, most common method is you have a patent and you say, gee, I'm going to use this patent and I'm going to allow it to provide me with commercial exclusivity while I sell a product covered by the patent. That's kind of like the 1700s version of IP monetization, right? The second strategy is to use the patent or patents to build a startup company, right? And this has become increasingly common since the Bayh-Dole Act passed 50 years ago. Essentially, it created an incentive for universities to commercialize patents. And now in sectors in high tech and pharma and biotech, this is really the first route of IP monetization that most folks undertake, right? They take a portfolio of patents and they decide to build a startup company around that. And then hopefully you'll transition to bullet point one, covering a product covered by those patents, right? A third option that's traditional, that is often used, is licensing patents to a third party. And this is often a strategic endeavor. And so a license is a contractual arrangement wherein I agree to allow a third party to produce a product, to use, make, sell, offer for sale, the things covered by the claims of my patent in exchange for some payment or royalty back to me, right? It's like renting an apartment as opposed to buying a house. And companies can do this for a lot of different reasons. So oftentimes when a company licenses to a third party, it's a strategic decision. Maybe they want to create a standard or develop a new market for a product. And they know that they can't do that all by themselves. So they license the IP for some aspect of their business in hopes that it creates an industry standard. You see this oftentimes, like kind of a silly, easy to understand example would be like connectors for electric vehicles. Those, I think there's like two versions of them. Those are widely licensed, right? And the idea is that, when Tesla invented their charger connection, they licensed it and made that IP available very inexpensively in hopes that it becomes the standard. And so, they create sort of a wide platform for charging of electric vehicles all across the world, right? That everyone uses the same standard. Sometimes it's about the company not being able to exploit a market opportunity. So let's say I'm a U.S. company, I don't have any ties to Europe as much as I might like to. I'm not in a position, I don't have the capital, the time, et cetera, the connections to market my product in Japan, even though I think it's a great market for the product. I might license to a Japanese partner and let them handle the Japanese business because they are going to do a better job of it than I am, and they're in a better position to exploit it. You can also cross-license with competitors to address FTO concerns, to access market opportunities that are otherwise barred by a competitor's patents, and even defray threats of litigation. And the idea here is we sort of work a trade, right? I build up a portfolio, and then I cross-license with you. And because you're giving me rights to your patents, and I'm giving you rights for my patents in exchange, maybe it's a very low cost transaction, but it gives me new business opportunities, right? And so those types of arrangements are fairly traditional. We see some newer types of arrangements that have sort of come on the scene more recently. Patent sales. So when you don't want to deal with the patent, you're not going to use it or commercialize it, you can sell that patent. And there are brokers now that will help broker sales of patents. And this allows you to recoup R&D costs. Of course, you're selling it to a third party, and with it go all the rights to make and use that invention, right? So this is something that's really only suitable for businesses either when they're sort of going under, right? Obviously, sort of bankruptcy sales and things like that, or when they're transitioning out of a given area or segment of the market, right? This IP no longer covers something they're going to be involved with. Sales then can be a very attractive way to sort of unlock that capital. Another area is enforcing the patents, right? You can do this yourself, essentially sue somebody for infringing your patent, right? And then you're going to hopefully get damages or royalties as a result of that lawsuit. You can do it yourself, or you can work with what is called a non-practicing entity, a third party who's sort of not selling or active in the market themselves. Their whole business is acquiring IP rights and then enforcing them against actors who are infringing. And so you can undertake this yourself, or you can license or sell your rights to an NPE who might undertake this effort, and in hopes of a judgment on the back end. In the last, say, 10 years, litigation financing in the area of IP litigation has become fairly common. It used to be, 15, 20 years ago, companies would not want to get into this world of patent enforcement because a district court patent litigation might easily cost $2 to $3 million. It's a huge investment. and most companies don't want to spend that kind of capital on a legal dispute with uncertain um, prospects, right? But there's now this whole world of litigation financing where essentially you go pitch your lawsuit to a fundraiser. They assess the potential damages, the likelihood of success. Then they incur all the costs associated with the litigation, including the attorney's fees, expert witness costs, all of that in exchange for a contractual portion of any recovery. And so that can be a very good, attractive option for folks. IP asset financing is always an option as well, in which you use IP as a collateral for a loan, or you enter into like a back licensing arrangement, where essentially I sell the patent to you. I sell the patent to Jalen. Jalen buys it, and then he licenses back to me the right to make and use and sell products covered by the patent in exchange for a royalty, right? And so that allows me to access some non-dilutive capital while maintaining my ability to commercialize a product covered by the claims. And that's really what IP asset financing is all about: is finding a way to get some money out of the asset while still being able to have the umbrella of IP protection to operate under. And then the last thing is a spin-off or a joint venture. And this is sort of another way of unlocking value from non-core assets. And essentially, the idea is if I have some non-core piece of intellectual property, this is not central to my business. If I put it in a spin-off or a joint venture, maybe I can attract investment and focus on the development of this new idea over here, and monetize the asset that way. As I mentioned, there's no one size fits all solution here. So definitely consult with IP counselors, strategic advisors to help you identify the best way to monetize your assets. Just to give you some idea, like if you look at kind of broadly speaking, the tech world, and you look at like Google and Apple and Tesla and Microsoft here as examples, they've all got very different IP monetization strategies they've employed in the last 10 or so years, right? Google has gone out and amassed an enormous portfolio of patents. And their goal is to try to protect, produce a shield for their smartphone products because they got into this new market. And defend against infringement threats, particularly with Apple and Samsung and others becoming more litigious. So they went out, they bought Motorola's Mobility's patent portfolio, 17,000 patents. They bought the whole company for 12.5 billion. They sold basically all of the assets except the patents and a few R&D pieces to Lenovo for 2.91 billion. So basically, let's just call it $10 billion. They bought these patents to provide themselves an umbrella for that sort of Android smartphone adventure that they've gone on, and help insulate them from threats of suits from Apple and Samsung and others, in spite of all of the suits that are happening in the smartphone space. Because of that strategy, Google's remained fairly well insulated. You have somebody like Apple who's pursued a very aggressive litigation and licensing strategy. They've asserted patents against numerous companies, Massimo, Samsung. They've extracted judgments and licensing revenue. They've really monetized their IP portfolio through aggressive litigation and licensing. Tesla has kind of done the opposite. They have a fairly large EV patent portfolio, and they essentially gave it away, or largely gave it away, in order to try to create standards in the EV market and build a market acceptance for electronic vehicles, right? So they've given away a lot of their charging and battery technology in hopes of having their systems become industry standards. And then Microsoft has pursued a really aggressive cross-licensing strategy with Samsung and LG and others to try to generate a little bit of revenue and avoid litigation, right? So even in similar industry, similar size companies, you see very different strategies depending on the markets they're after, their positioning in those markets, and their portfolio. So with that, happy to answer any questions. Apologies for running just a little bit long. Hopefully it wasn't too boring, but yes, if you have any questions, feel free to to raise your hands or ask them in the chat.
Does look like we have a question in the chat from Greg Bouchard.
Yeah, okay, great. So Greg, I don't think you can assume, generally speaking, that a university has done a freedom to operate analysis when you license a portfolio from a university. You can certainly ask sort of the licensing officer at the university whether that's something they've investigated. We do a lot of work with universities. I think we represent something like 50 universities, and probably a little under half of my practice is with university clients. And it's very rare that they ask us to perform a freedom to operate analysis. So I don't think I would assume one has been conducted. The only other thing I'll add there is that oftentimes when deciding whether or not to file a patent application, and when they're thinking about identifying potential licensees for a technology, they will perform some landscape searching to understand what's been done before, who else is out there and is active in this space. There are even consultants whose whole job is doing those types of landscape and market analysis for universities to help guide their filing decisions. If I was going to license a portfolio from a university, I would ask the licensing officer whether such an analysis was done and see whether you can get a copy of that. And while it's not an FTO analysis, sort of ties back to what I was talking about earlier, the right size approach. That'll give you a good picture of who's in the market and what patents exist, and you can maybe look at those and get some sense for what concerns there may be. Hopefully that addresses your question.
Okay. AJ, thank you so much for joining us today on this call. We really enjoyed your presentation. I've got a few of my takeaways written down. From the beginning of the presentation, I wrote down, don't disclose too early. You want to align your IP strategy with your company's value proposition. You have to educate your stakeholders about IP. I remember the piece about jurisdiction of interest. So if you're making semiconductors or you're in that industry, you need to be filed in Taiwan, more than likely. And then there's a lot of different ways to monetize your IP. Do remember that this presentation and this recording will be sent out. So if you have any questions or want to get in touch with AJ, you can find his email right here. AJ, thank you. So please keep an eye out for some of our upcoming programs and events. So March 26th, we're having our Tulane Innovation Day in coordination with New Orleans Entrepreneur Week. We are also going to have a webinar on March 26th on bookkeeping and financial forecasting for startups. And then join us April 8th through the 10th for the Tulane Research, Innovation, and Creativity Summit, also known as TRIX. Thank you all for joining us.